Okay, well, good morning. We are just thrilled to see you all here today, and we're also thrilled to welcome a variety of different, actually hundreds of people on our webcast today. We are just delighted to have with us today Vicki Lipnic, the acting chair of the EEOC. It's not usually my style to go through biographical information for people, but just to ensure you understand sort of the significance of the conversation we're going to witness here today, I did want to just go through some information both about Vicki and about Jerry Maatman, my partner and the editor of Seyfarth's 13th Annual Workplace Class Action Litigation Report, which we are celebrating today as a book launch in conjunction with this event. So first, I would love to introduce Vicki. I'm sure many of you know Vicki Lipnic from her current role with the EEOC, but she has a really very interesting professional history that I think many of you would love to hear about because it provides some context for how she's going to speak with us today and some insights that she might share. So Vicki was appointed to her current position as acting chair by President Trump on January 25th. She actually began with the EEOC as a commissioner in April of 2010. So she's been there for some time. In November 2015, she was actually confirmed by the Senate for a second term, which is ending on July 1 of 2020. So Vicki may talk a little bit more about, sort of what that means in the current political climate. And this is what's interesting, is Vicki comes to the EEOC with a storied history and a lot of experience on a variety of different labor and employment issues, which I think are certainly relevant to her current work and to her discussion today. So we are very lucky to call Vicki an alumni of Seyfarth Shaw. She was with our Washington, D.C. office before joining the EEOC. Before that, from 2002 to 2009, she served as the Assistant Secretary of the Labor Labor for Employment Standards. There, she oversaw the DOL's Wage and Hour Division, the Office of Federal Contract Compliance Programs, the Office of Workers' Compensation Programs, as well as the Labor Management Standards. She worked on employment issues in Capitol Hill before that, and she also worked at the U.S. Postal Service. And a really fun fact to just go in deeper into her history with government. She grew up as the mayor's daughter. Her father was actually the mayor of her hometown in Pennsylvania for 25 years. So I think it's just fascinating, Vicki's history. So thank you, Vicki, for being here and welcome. I'll turn over and do a quick background on Jerry Maatman, our partner, who really kicked off this entire event for us today here at Seyfarth Shaw. He's really one of our top class action defense lawyers here at the firm and, quite frankly, the country. Jerry right now is handling one of the largest wage and hour cases, if not the largest wage and hour class case in the country, as well as the largest private class action currently pending in the U.S. Alleging employment discrimination. If he wasn't already busy, he is the co-chair of our firm's class action defense group. He is the senior editor and author of the class action report that you'll see here, and I'll talk about here in a minute, in the back of the room. And this is actually the book kickoff event for that treatise. Jerry's the lead defense counsel in 2 of the 5 largest EEOC cases pending in the country right now. He also authored the amicus brief in the U.S. Supreme Court on the Walmart stores versus Dukes case, as well as in the Maatman versus EEOC case. Jerry is one of the most credentialed lawyers in our class action defense group, and he is recognized that way in the industry. He was selected 4 years running as one of the top 5 employment attorneys in the country in client service, which is a really amazing recognition for somebody of his substantive stature. He's also been named by Law 360 as one of the top 5 employment lawyers in the country, and in fact got an MVP award for that. So between Jerry and Vicki, I think you're in for a very interesting and very fun discussion today, and certainly substantive given our political and legal climate right now, in looking at the trends and where we might be going with some different issues in the class action landscape. So a couple of words before I turn it over to Jerry and Vicki about our workplace class action report, We're tremendously thrilled about the report. Jerry and his team put an amazing amount of work into this every year, and it's really the single treatise about class actions in the employment context of its type published every year. And so we're very lucky to have this resource and Jerry as our editor. I wanted to just show you the book. For those of you in Chicago, we have this book in the back. You can take a copy with you at the end of today's seminar. And then for those of you attending via webcast, we have this available in an e-book format that will be sent to everyone who's a participant today. There was a recent review of the report, and I'll just end with this because it's rather remarkable. It's kind of an amazing quote. The report was reviewed by the Employment Practices Liability Consultant magazine, and the magazine said the report is a must-have for in-depth analysis of employment-related class action litigation. Anyone who practices in this area, whether as an attorney, risk manager, underwriter, or broker, cannot afford to be without it. Importantly, the report is the only publication of its kind in the United States. So with that, we clearly have two amazing experts. We're thrilled to have you today, and I'll turn it over to Jerry and Vicki.
Okay, there you go.
Thanks very much, Laura, for that nice introduction. Good morning, everyone. I have to say, I was leaving Washington the other day, and it was 72 degrees, and when I got home that night and I was packing my bag quickly and throwing clothes in the bag, and I thought, oh, right, Chicago. I should take a hat and gloves and wear something warm. So anyway, well, first of all, I want to, it's nice to be back at Seyfarth Shaw. And I wanted to ask, is there anyone here from the EEOC Chicago District Office? Anyone in the room? There might be, some people might be listening. This trip also afforded me a chance to visit with the Chicago District Office yesterday, which I was really happy to do. Well, I want to thank Jerry for asking me to participate in this event. He actually asked me to participate in this before I was named acting chair. But I also want to publicly thank President Trump for appointing me as the acting chair and entrusting me with the responsibility of the EEOC. And I also want to thank Jenny Yang, who is now Commissioner Yang and our immediate past chair of the EEOC for the transition that we've had at the Commission. We are a very collegial group at the EEOC. We are now 4 commissioners. Commissioner Connie Barker was not reconfirmed for her position at the end of the Senate term in December. So I am 1 Republican, 3 Democrat commissioners, Jenny Yang, my very good friend Hy Feldblum, and Commissioner Charlotte Burrows. But we have operated in a bipartisan fashion in the time that I've been at the Commission, and I fully expect and hope that we will continue to do so. I did want to say just a couple of things, though, at the outset, which is that, it's a new administration, but the EEOC remains committed to its core values and its core mission, and that is not going to change. We are an enforcement agency, and we enforce some of the most important civil rights laws in the country. Having said that, it is a new administration, and President Trump has made it very clear that he is interested in jobs, jobs, jobs. And for many years in my time at the Commission, I have been saying that we are the Equal Employment Opportunity Commission. Underscore employment opportunity. And I think it is incumbent upon us at the EEOC in terms of our approach, particularly on policy, to make sure that we are doing things in a way where we recognize the dynamic workforce that we all of you certainly live with, and where we recognize the kind of business practices that are necessary for companies to be competitive today, and that those thoughts and notions get incorporated into our policymaking. So the President has also made it clear that in terms of regulatory policy in particular, and we play a big role in that, that where there are opportunities to refocus things in a way that will foster economic growth and foster job growth, that is something that we should be mindful of, and we are not exempt from that at the EEOC. I do think that it is certainly the case that, again, I don't think it has to be the case, I should say, that we have to, in our approach to policy, be at odds with the employer community in everything. I have spent many years working on lots of regulations and lots of policies, and oftentimes the approach is to try to write the complete contingent claims contract, which we all know there is no such thing as the complete contingent claims contract, and trying to do that in regulatory policy often doesn't work. So again, I am certainly committed and always have been to the mission of the agency, but I think that our approach, it is a new day, and to the extent and where we can be able to help foster employment opportunity and economic growth, that is something that we will be focused on. Again, we are the Equal Employment Opportunity Commission, _employment opportunity. And that is something that I think we need to have a focus on. With that, let me turn to some slides, and I will try to go through these quickly. Oh, there we go. So as I mentioned, we are now a 4-member commission. So the Commissioner Yang, I want to call Jenny Chair Yang, is still at the commission. Her term will expire July 1st of this year. And so President Trump will nominate 2 new Republican members of the commission. There's a seat open now that had been the seat that Commissioner Barker held, and then Commissioner Yang's term will expire in July, and our general counsel's position is open. Most of you here are familiar. David Lopez, who had been the general counsel during the Obama administration, had actually announced his resignation before the end of the Obama administration, and David left the agency in December under the Federal Vacancies Act. By operation of law, the career deputy general counsel becomes the acting general counsel. So we currently have an acting general counsel, Jim Lee, who's been with the agency for many years and very experienced. But he's in charge of the general counsel's office right now. So it will take some time. The EEOC is one of many boards and commissions across the government where the administration will be filling out positions. So it will take some time, I think, until those positions are filled. And the ones that I'm mentioning, the 2 commissioners' positions and the general counsel's position, are all presidential appointments, Senate confirmed. And that process in and of itself takes some time. So, but the work of the EEOC goes on, and as I mentioned, we are a very collegial group at the commission, and I've worked in a bipartisan fashion for many years with my colleagues on the commission. In particular, my colleague, Commissioner Feldblum, although I always like to kid her that she thinks that bipartisan means that I agree with everything she has to say. And if I don't, then it's partisan. So just let me give you some basics in terms of things that we dealt with over the last year. So, and this is all from the most recent fiscal year, 2016. We had 91,000 charges filed in the last year. I think some of you have been aware of this over the past couple of years, that retaliation is now the single highest category that we see in terms of charges. Race, constituted 35% of our charges, and disability another 30%. We at the same time, those are incoming charges. We resolved another 97,000 charges during the year. 15,000 of those had merit resolution. So that can be everything from a mediation to something that gets resolved at a conciliation stage. We had 3,100 reasonable cause findings, 1,300 successful conciliations, 1,700 unsuccessful conciliations, and this is all the monetary relief, $348 million. That is before litigation. So in terms of what the agency recovered. Just to give you, I wanted to, for my own purposes, get some more historical perspective. So if I actually went back to fiscal year 2002, and this will give you some idea of what the charge filings have been like. When I came on board on the commission in 2002, there had been a pretty significant increase, and we were receiving close to 100,000 charges per year. So that's been down a little bit, and there has been a big effort at the commission to reduce the backlog, and that is something that is still a priority. Congress cares a great deal about it, and everyone at the commission cares a great deal about it in all of our field offices across the country. Our conciliation rate, and Jerry and I were talking about this a little bit earlier, and I'd be interested later when we have time for discussion. The conciliation rate, has been the raw number of successful conciliations has been relatively stable over the past few years, but we have had a higher rate of unsuccessful or a higher rate of conciliations that have not been unsuccessful, which is a lot of double negatives. But the point being that there seems to be an increase in willingness to conciliate, and I'm very curious and would be interested in people's thoughts on what is driving that. I've been very interested for the past 2 years on what might be driving more successful conciliations. I don't know. I'm very curious if it's insurance coverage related. I don't know what the factors are. Costs of litigation. I'm in a room of lawyers, so you can all educate me about that. In terms of the lawsuits that we've filed, though, this has been declining, and you'll see. So last year we filed in federal district court 86 merit suits. 18 of those were systemic. 55 were individual suits. 13 non-systemic class. And then in addition to that, our district offices resolved another 139 merit suits. So that was an additional $52 million in monetary recovery. The next slide, this is what I wanted to show you in particular. So this is a comparison of the number of suits that were filed during the Bush administration and the number of suits that were filed in the Obama administration. And I'm not doing this, I'm not showing you this for some, to make a political point, but I want you to look at the raw numbers of how, the red, of course, is the Bush administration, and the blue is the Obama administration. But if you look at, so the beginning of the Bush administration, fiscal year 2002, there were almost 350 lawsuits filed. The first year of the Obama administration, 250. And we went from 250 down to 86 lawsuits last year. But at one point, a decade ago, there were over 400 lawsuits being filed by the EEOC nationwide. And now it is true that we have had an emphasis on systemic work. There was a systemic task force that had been put together in 2006, and much of that has driven, this will give you the sense of the declining number of suits in federal district court. And so when I've, been trying to ask about this, and a lot of times people will say, well, our systemic program, we have more systemic cases, but this gives you an idea of just over the last 6 years. So in yellow is the number of systemic cases we've had every year compared to the number of individual suits. I want to make a point about systemic, because this has occupied a lot of the Commission's work over the past few years. I am very committed to the systemic program. Every enforcement agency has to put its resources where it can have the most impact. And I am also, though, for the work that the EEOC does, I'm a big believer that the EEOC has to do a substantial amount of individual cases, because individual cases tell a story of discrimination. And they tell a story that can have an impact different from the number of people represented in a particular case, but it can have a broad impact in terms of public awareness. So I do think it's important for us to remain committed to systemic, but individual cases matter. I am not of the view that we should be all systemic all the time. I also think in terms of systemic cases that we probably need to, at a commission level, take a hard look at the amount of resources that we as an enforcement agency have to commit to systemic cases and how it is impacting our ability to do our work. We only have so many resources. And so it's important that we do cases, systemic cases, but I think we have to be strategic about them. So in the same way that, and Jerry has far more experience related to other class cases, but in the same way that I think you've seen a course correction by many in the plaintiff's bar over the past few years, certainly since the Dukes v. Walmart case, of being more targeted, perhaps more regional. I think that's something that we should probably take a look at. It seems to me that we can have an impact, and if the purpose of systemic is to have a broad impact, we, the EEOC, can look at a policy or a practice, and if we are, let's say, bringing a case against a major nationwide employer, we can have an impact on that policy if we prosecute that case in a region perhaps as effectively as trying to do it nationwide. And that's something that I think I want, intend to, and I've had a chance to visit with the Chicago district office yesterday. I was in New York last week. But I do think that we need to do a hard assessment within the agency of how we are best using our resources. And if that means a bit of a course correction on the systemic program, I think that's something that's necessary. So let me mention the monetary benefits. As I mentioned, we've covered $52 million on that. Tell me how I'm doing on time. Okay. I'm just going to mention a couple policy things that we did over the last year, and then I'll mention one other thing and then turn it over to Jerry. So we've had a very busy agenda at the Commission on a number of policy things over the past year. We completed our rules on the wellness program under ADA and GINA. Some of this may be, and I don't know, but impacted by what will happen with the Affordable Care Act. Now, I will say that the wellness programs were the one area of the Affordable Care Act where there was bipartisan agreement when they passed the Affordable Care Act in Congress. So if Congress, makes some change on the Affordable Care Act, how that will impact wellness and then would have some spillover effect to our regs, I don't know. But our regs are there and in place. And I do fully recognize, for those of you from corporations, that you have a long lead time that you need in terms of knowing what the rules are you have to follow in terms of getting your wellness plan. So that is something that we're certainly cognizant of. We issued guidance on retaliation. Again, part of that was, we felt like we needed to update our guidance on retaliation because retaliation claims are so high. We revised the EEO1 to collect pay data. I'm sure people are going to ask me questions about that, so I will table that for now. We did enforcement guidance on national origin. We put out, and this is at a sort of a smaller level, a resource document about mental health conditions in the workplace. And for those interested in things that we do in the federal sector, we did regulations under Section 501 of the Rehab Act. Last thing I'm going to mention, two last things. One is I co-chaired a task force with Commissioner Feldblum. We issued our report in June on a task force on harassment in the workplace. And we had impaneled, and this was an 18-month effort, a group of outside experts, lawyers, but also academics, industrial psychologists, sociologists, to people who had actually studied harassment and over the past couple of decades. The idea being we were very interested in what can we do to prevent harassment. We see 30 years later, and we released our report 30 years after the Supreme Court case in the Meritor Savings Bank case. We see far too many charges of harassment, particularly sexual harassment, at the EEOC. And even though all of you are involved in this, there is a huge industry of compliance and training. This continues to be plague many of our workplaces. So we were interested in what sort of new approaches can there be in terms of preventing harassment. We started off with our task force members immediately saying, look, we all know what is legally actionable. What we're concerned about is trying to have some new approaches to prevention. And there were a number of recommendations that we made. Our report is available on the website. But those included, for all of you, looking at your training and perhaps modifying your training. We at the EEOC are, we consider the task force report really one step in, that was a first step in our process on this. We are internally looking at, are there other approaches to training that may be more effective? There were two things that we had recommended. One was workplace civility training, which is sort of a new kind of model in a lot of the training world. And the other is bystander intervention training. Now, we admitted we don't know if that works in a workplace. We were borrowing the concept from, if any of you have college students in your household, but the effort on college campuses about sexual assault on campus and looking at bystander intervention, and we are, offered the suggestion that maybe this is something that could be used in workplaces. There are no current training modules about it. We are actually having an internal meeting next week at the EEOC where we have invited in some experts and are going to explore this further. But the point being, the report that we issued was sort of one step, and issues related to harassment are things that I still care a great deal about. I'm not going to talk about, we made changes to the strategic enforcement plan over the past year, and I had actually voted against this. I had voted against it because it has been my firm view in the time that I've been at the Commission that the commission, and by that I do mean the people appointed by the president and confirmed by the Senate, should have the opportunity to see and vote on more litigation that gets filed in federal district court, not less. The general counsel, most of that authority is delegated to the general counsel, except under certain circumstances. And in this latest strategic enforcement plan, we ratcheted that back in a way that I did not think we should be doing. So I am a big believer in the commission should speak first. We should not be advancing positions and arguments first in legal briefs. There should be some opportunity for the commission to have been heard, and it is important for the governance of the commission that the commission put its by vote imprimatur on whether it's litigation that gets filed in federal district court and certainly in any policy matters, which we already do. I do not by any means think the commission has to vote on every piece of litigation. I do believe we need to vote on more than we have done over the past 7 years. Later on, we'll talk a little bit about conciliations. I was going to mention, and Jerry has lots of experience with this, the mock mining case from a couple of years ago, which went up to the Supreme Court, and the Supreme Court in a 9-0 decision against the EEOC. The EEOC had been arguing that we did not think that there was judicial review on conciliation, and certainly it has been a litigation strategy over the past certainly 6 or 7 years to really challenge the pre-suit processes of the EEOC, whether that's about conciliations or investigations. And so that issue of judicial review that went up to the Supreme Court, and while on its face the commission lost in that decision 9-0, I actually think that decision was a victory for the EEOC because the language, the court did not adopt a good faith standard for conciliations and said that courts only needed to do, while they had the ability to do judicial review, they only need to do a bare bones review. I am committed to making sure that we have a good conciliation program, but which again, you saw, our rates of conciliation are more successful, but that all of the people at the EEOC who deal with conciliations, our investigators, all the people in our district offices, that they have good training, and that despite the language of the bare bones review of the mock mining decision, that we are fully prepared at conciliations, our staff, and that we make sure that we go beyond what you would think is required under mock mining. So I'll stop there.
Okay. Well, it is an absolute privilege and honor to be on the same stage with Vicki, and thank you so much for honoring us on our book launch today. It reminds me I'm one of maybe the few individuals in the room who remember a popular TV commercial called "When E.F. Hutton Speaks, the Customer Listens," and what an opportunity to have the government in the person of the chair of the committee talk to us today. So thank you so very much. My job is to take you on a tour, a whirlwind one, of about 1,300 class action rulings that occurred in 2016 and distill it down into 6 trends and what it means to you sitting here today and what it means to corporate America. So in 20 minutes, what I'm going to try and do is talk about these 6 trends, what they meant for employers in 2016, and what you can expect in 2017. And the first trend was the Supreme Court. Its decisions, at least in the workplace class action world, are the key driver of risk and what are called bet the company cases. It, in essence, drives litigation dynamics. Some think the court or characterize the justices on the court as pro-worker. Some say pro-business. Some say pro-class action. Some say anti-class action. In my mind, I think the analysis is a little more nuanced and anything but one-dimensional. The way I view it, at least in the practical trenches of the litigation world in that I live, is cases are either courthouse door openers or courthouse door closers. They either create barriers or they eliminate walls that allow litigants to get into court. They are either sharp and well-defined, or they have a gray area, and God knows when lawyers encounter a gray area, they can wreak havoc on some of the issues at hand. But I'm often asked, of the 1,300 cases that are reviewed in the book, what are the two most critical decisions? They're right here: the Tyson's Food case and the Spokio case. The Tyson Food case, I think, has a lot to do with risks that corporate America will face in 2017. Vicki had mentioned the seminal Dukes v. Walmart case from 2011, published in the Wall Street Journal the day of the decision. This changes the dynamics for companies, makes it much harder for workers to sue, to band together, to bring class actions and successfully prosecute their cases. That decision still is the 800-pound gorilla in the courthouse in 2016, cited in over 600 cases. Truly, lawyers, companies have to come to grips with what Dukes v. Walmart means in the world in which corporations find themselves litigating these bet the company cases today. But Tyson Foods opened the door and created a workaround for the plaintiff's bar, in my mind, that makes it easier for them to certify cases, easier to create the conditions for opportunistic settlements, and will be a driver of litigation risks. In essence, it opened a door that Dukes v. Walmart closed. It in and of itself, even though decided in mid-year of 2016, is cited over 100 times by courts around the United States, encountering now new class action issues as a result of these new guidelines, these new field goal posts that have been created by the Supreme Court. The other big case was Spokio, also an employment case about onboarding or hiring, and having to do with the concept of who may sue and what may they sue about, in terms of these laws that Congress allows workers to sue not necessarily because they have a pocketbook injury, but because there's a violation of statutory law. Very gray, hard to figure out, door opener, lowers the barriers. It's cited over 360 times by courts, and I think in the 6 months since Spokio decided, we've seen a lot more cases in this particular area and has generated more cases. So my prediction for 2017 is lawyers representing workers will be citing these two cases, relying on these two cases to try and ring the bell and create opportunistic conditions to settle. Trend number two, class action settlements, much, much lower. They were about $2.5 billion in 2015, almost came down $1 billion in 2016. What caused that? This slide shows the various settlement values in the various substantive areas we look at: wage and hour cases, employment discrimination cases, employee benefit cases known as ERISA cases, statutory causes of action, and government employment litigation. And the bar to look at here, and the reason the color is green, are the greenbacks in the wage and hour area. And if you look at the settlement numbers and the employment discrimination, you see what I call the Walmart effect. And you see the declining numbers starting in 2011 when the Supreme Court issues its decision. It begins to take hold. It causes a calculation of litigation risks that makes it easier for companies to defend these sorts of cases, harder for plaintiffs to bring them and convert these case filings into big settlements. You had a couple of rising years between 2013 and 15, and that's because cases were in the pipeline. I think what we saw in 2016 is Walmart has come full circle and has impacted the ability of these plaintiffs' lawyers to convert big lawsuits into big settlements. But then look at wage and hour cases. We have over the last 24 months a threefold increase. Why is that? Well, the upward arc of this rocket has a lot to do with Walmart not being accepted in courthouses in wage and hour cases, and this Tyson Foods workaround makes it easier for the plaintiff's bar to bring these cases, get them certified, and then convert those certifications into large settlement numbers. Trend 2, government enforcement litigation. Vicki talked about it. In 2016, they were the second lowest amount in the last decade. Who knows what's going to happen under our new White House? Who knows what will happen in terms of driving those settlements? But we're on the downward side of a bell jar curve when it comes to these governmental settlements. Trend 3, a very dense slide, but this is the analysis that we do in terms of looking at decisions every morning, logging them into our book and analyzing them to figure out and analyze the categories of these rulings. Last year there were 244 class certification orders. If you ask me what drives this litigation, I'd say it's not unlike buying a house or a building. Location, location, location is everything. Who's your judge? What are the standards in that state? And what is going to happen with your case involves a lot about where you are sued. And you'll see on the left coast, the state of California, and the right coast, the area of Metro New York, known as the 9th and 2nd Circuit, which have become magnet jurisdictions. Most Fortune 1000 companies do business in both those states, and invariably, in these bet the company cases, plaintiffs' lawyers pick those two courts to bring their cases because the certification decisions and the law is decidedly more favorable to workers' lawyers than to defense lawyers, and the certification numbers are higher, hence the settlements being higher. So if you looked at the actual statistics of what would happen to your case, you'd see that in the employment discrimination arena, it's a jump ball. 50-50 in terms of winning or losing that certification battle. When it comes to employee benefits, a little bit more than a jump ball, 2/3, 1/3 of these ERISA class actions. But when it comes to wage and hour, plaintiffs' lawyers are winning 76%, 3/4 of all class actions that are brought. So in essence, in my analysis, this reflects or manifests what I call the investment theory of class action litigation. The plaintiff's lawyers follow the money. Bringing a wage and hour case is a low investment. You need one person, two people. You don't have to hire an expert. In contrast, in an ERISA case or an employment discrimination case, you must hire a statistician, a labor economist, at about $250,000, conduct a year's worth of discovery before you even get to certification. Yet in the wage and hour area, where the Dukes v. Walmart case has not attached, where the barriers to certification are much lower, plaintiffs' attorneys can move for certification within 30 days and convert these at a rate of 3/4 or 76% to create the conditions for a settlement. The holy grail in what I do is class certification. Courts describe it as what's called hydraulic pressure imposed on an employer to settle. That might be fancy schmancy language in a courthouse. What I feel is it's like holding an angry tiger who hasn't had dinner for 2 nights and you're holding it with one hand. That's what it's like when a case gets certified and you're dealing with one of these situations. So what does that do with case filings? Trend number 4 is plaintiffs' lawyers are following the money. And this slide shows that over the last year, the most rising tide is with wage and hour cases. And every year, actually since about 1999, the number of wage and hour cases brought as collective or class actions has risen every year. 2016 was the very first time in 15 years it actually went down. I think it's an aberration. I think it'll go up next year. But what this slide tells you is right now inside federal and state courts, you have 2 years worth of the most of these wage and hour cases ever being filed in the history of mankind. So there are a lot of wage and hour cases in the system. And in essence, success begets copycats. And workers reading about these things on social media, the big, huge settlements, the certification numbers, that success begets copycats who file more and more of these cases. When we get to trend 5, we actually looked at the statistics underlining these wage and hour filings. And in those who are following along on computer in our podcast, hopefully this slide's on the screen. For others, it's in the book. in the handout here in Chicago, but what it shows is the great number of cases and the certifications that occur on the left and right coasts. In the Second Circuit in Metro New York and the Ninth Circuit in Metro San Francisco, where consistently the larger companies are being sued and where plaintiffs' lawyers are converting these filings into certification rulings. So in 2017, you have a new president, you have a government committed to building jobs, you have ever active social media in the workplace, wherever. I see it when I go to dinner with the kids and looking at that social media. You have plaintiffs' lawyers getting record number settlements, certifying cases at a clip of 76%. Those are the conditions that will lead probably to more cases. I'm often asked, if I have $1,000 to spend on compliance activities, where should I spend that money? And I would say spend $999 out of that budget on examining how people are paid and getting it right in terms of how you compensate them, how you pay them, and remember that mosaic quilt of state law requirements, local law requirements, and then federal law requirements. If it were easy, it would be easy. There probably wouldn't be any of these cases. So obviously it's a Rubik's Cube of compliance and a difficult situation, but I think that's where the money is for the plaintiff's bar, and that's where the money ought to be for compliance. This shows the success, however, in the last year that the defense bar has had in wage and hour cases in what's called the decertification process. After discovery takes place, after a case has been certified, those who have the spine and backbone to take on the plaintiff's bar and stick with the case have been able to decertify these cases at about 50%. And that's where the hard science goes in for the defense teams to try and drive down those numbers and win. I think the defense is doing a good job, and one of these years we're going to push that number over 50%. But again, plaintiffs' lawyers knowing that know that if they can get that initial certification, they're going to do well. The last trend was government litigation. Vicki showed you the slide of the declining number of cases brought in the Obama administration as compared to the Bush administration. My sense, as an outsider looking in, probably lesser numbers of governmental enforcement lawsuits being filed both by the EEOC and the Department of Labor, but something inevitably is going to fill that void. That void, I think, will be filled by state agencies. The state of California, I've heard, has some sheriffs there who run agencies that are very litigation focused, and the private plaintiffs bar inevitably is going to fill that void. So the fact that we may have a White House committed to job creation and elimination of regulation, and perhaps maybe a little less in the way of filing lawsuits, doesn't equate to no reason to not focus on compliance activities, to get your story right, and try and wake up every morning to be the best employer you can be, to position yourself to defeat these cases or stop from being sued in the first instance. So that's about a 17-minute tour of about 1,300 rulings and what's going on throughout the United States. And just put in a plug for our blog for those who enjoy following these things on a daily basis. This is our blog where we write about this on a daily basis. So thank you very much.
Thank you so much, Sherry and Vicki. We had some questions that were submitted in advance, and so I wanted to just take the last remaining minutes of our session today to share some of those and see if you have some thoughts or additional insights you might share with our audience today. And again, I realized I didn't have a little name tag here, so I'm Laura Mecklin. I'm the Vice Chair of our Labor and Employment Department for the country here at Seyfarth Shaw, just in case you didn't know my face. So it's a pleasure to have you all here. So I think one for Vicki that might be interesting for you to touch on a little bit. You already touched a bit around the conciliation process, but do you anticipate any changes to the EEOC's litigation enforcement priorities with the new administration?
Well, if you look at our, perhaps, but if you look at our strategic enforcement plan, most of our issues that we talked about there in terms of protecting vulnerable workers, access to the legal system, looking at we have particular industries. I think that most of that will probably stay the same. I'm very interested in equal pay issues. Now, we have the EEOC for many, many years has not brought a lot of Equal Pay Act cases. We don't get a lot of charges in the Equal Pay Act area. I think we have a couple of, in particular, one of our regional attorneys, Deborah Lawrence, who's been pretty skilled at bringing Equal Pay Act cases. So that's something that I would consider a priority. It is also, in fact, a priority in our strategic enforcement plan. So for the most part, in terms of sort of area-wise, subject area-wise, I think that much of our emphasis will be the same. We do talk about, in our strategic enforcement plan, we talked about, evolving employment relationships. So, joint employer relationships, staffing agencies, things like that. And that is something that I think we will continue to give some attention to. The other thing that I will mention in terms of priorities, this year is the 50th anniversary of the Age Discrimination in Employment Act. And so I expect that we will be doing a number of things related to that this year. But issues about age discrimination, I think, are, aside from sort of our traditional, what we enforce, are something that should get a high profile this year.
Excellent, thank you. So let's turn one to Jerry. I think with the trends that you mentioned arising from the class action report, it would be interesting to hear from you about how employers can possibly lower their litigation risk through counseling or other type activities pre-litigation or outside of litigation.
Well, I'm a big believer in the notion that none of these cases ever come as a surprise. There are warning signs, and if the radar is out, an employer knows when it's coming in terms of employee grievances. And so I think any efforts made internally at a company to resolve issues through the HR department or to do or create notions of workplace due process so a worker thinks they're being treated fairly. They don't have to vote with their feet and go visit the EEOC or the Department of Labor. Please file a lawsuit on my behalf, or visit a plaintiff's lawyer to do so. I think one of the key defining moments of 2017, perhaps 2018, will be what the U.S. Supreme Court decides to do with the current dispute over the use of workplace arbitration programs. I do believe that use of an arbitration program, if carefully crafted and appropriately implemented, can significantly reduce exposure to class action risks. That case or set of cases will be argued sometime in the fall of 2017. More likely than not, President Trump's new nominee for the bench, hopefully or maybe, gets appointed to the Supreme Court and takes his seat, and so there'll be a full complement of 9 judges. I think that will be the decision next year. It's called the EPIC case, and it will be an EPIC case. Will determine the ability of employers to utilize those sorts of arrangements and agreements and processes to control, manage, and reduce the cost or exposure of these class actions. So I would follow those developments closely and determine what to do based and take your cue on what comes out of Washington, D.C.
Excellent. Yeah, EPIC's a big trend that we're all watching. So one more for Vicki, and I think you referenced this earlier. Somebody would take my head off if I didn't ask about the future of the EEO1 compensation requirements. So can you speak to the EEO1 future?
Well, here's what I can say about the EEO1. So the modified EEO1, which was approved by the Office of Management and Budget under the Paperwork Reduction Act, and adds all sorts of the reporting requirements for compensation. I voted against the modified EEO1 form. back to where I started, generally have the view that we have to be smart about our regulatory policy, and that we also have to not be trying to have 30-year-old solutions to modern-day problems. So I think some of the decisions that were made in the final modified EEO1 form, just in terms of looking at the W-2 information rather than the base salary, things like that are things that I would want to take a look at. But I think overall, there needs to be a reevaluation of the costs and the benefits. Again, I mean, that's certainly the direction of the president in terms of regulatory policy, and that the EEO1 to me fits squarely into having to make that type of evaluation. Having said that, keep in mind that the commission operates by vote, and we are a 4-member commission right now, as I said, and as we are currently composed, I am the 1 member who voted against the modified EEO1 form. So it is something that I look forward to having a conversation with my colleagues about in the future.
Wonderful, thank you. So I think we're just nearing the end of our time. One final question, I think, Jerry, if you can address this, in a minute or less. It's a very easy topic. Let's look at the trending Supreme Court. I know you mentioned EPIC before, but are there additional changes at the Supreme Court level that would impact class and systemic litigation?
Well, I think the current complement or the ideological divide between conservatives or liberals, or the view of what class action litigation is all about and can accomplish. Is it a vehicle for social change, a vehicle for good, or is it something that's been abused, and is it a way for certain lawyers to get rich while their clients are left behind? And so while Justice Scalia was alive and held force on the Supreme Court, he seemed to be a consistent voice who would write the big opinions. He's obviously the author of Dukes v. Walmart, that really created rigorous application of the applicable rules on how a case would be prosecuted and how it would be defended. He is not going to be there. Who knows the views of his successor? And so I think there's a bit of flux, a bit of the unknown, and I think in those gray areas there tends to be more litigation rather than less. And what I've seen over the last few years is a wholesale rebooting, rethinking, new approach to the way in which class action cases are crafted and litigated. And so if you're a company having to operate in that sort of litigation environment, you need to be nimble. You need to be able to respond to these new theories, understand what's going around the country. And so not unlike many other aspects of life, very difficult in a complex environment like that to see your way through consistently. It's
Wonderful.
A tough area.
It's a tough area. So with that, it's a great ending note, I think, to our overview today. Thank you so much for everyone here in the room and for the folks who have joined us by computer. And really, thanks to our stars of the show today. Thank you to Jerry Maatman and certainly to our acting chair, Vicki Lipnic. So thank you so much for your assistance and your insights today. We look forward to continuing the conversation.
Thank you.
Thanks, everyone.